Welcome to the Kemp IT Law vlog. I'm Nooreen Ajmal. The recent decision by the High Court in Gama Aviation has found that a clause preventing unilateral termination of a contract without written notice did not prevent the contract from being informally novated. In 2008, International Jet Club, or IJC, and the defendant M entered an agreement for maintenance and repair services to be provided by IJC to M's aircraft. The duration clause of the agreement stated, "This agreement shall commence from the date of this agreement and shall continue until such time as either party gives the other not less than 3 months' notice in writing of termination." Further, there was a standard variation clause stating any variation to the agreement had to be in writing. In 2014, IJC was part of a company restructuring that meant it became a subsidiary of Gama Aviation, or Gama. In 2017, the aircraft was moved to Bermuda, where Gama held the regulatory authority to service the aircraft, and from March 2017, it was Gama rather than IJC that was providing the service and invoicing M at M's request. An increase in fees was agreed between Gama and M paid the invoices. There were also negotiations for a new agreement between Gama and M, but this was not ever finalised. This course of dealing continued until January 2019, when M failed to pay Gama. Gama sued M for its unpaid fees and argued that the parties' conduct meant the agreement had effectively been novated from IJC to Gama in 2017. M's argument was that the novation was ineffective because the duration clause in the agreement meant there was an exclusive means of terminating the contract, that being given 3 months' notice in writing. It also said the standard variation clause meant the agreement could not be varied without agreement of the parties in writing. The court found in favour of Gama and held the novation had taken place based on the facts and the actions of the parties. As held in the case of CCOM versus Knowledge Pool Group, it said novation can be inferred by conduct. With regards to the duration clause, the High Court held this set out the start date and the end date of the agreement and a means for unilateral termination, so it had no bearing on whether the parties could terminate by mutual agreement, and there was no bar in the contract for termination by novation. The court also applied the principle of estoppel, stating that by its conduct, M was estopped from denying the novation had taken place, given Gama had provided services and incurred expenses in the understanding it would be paid for these. The case is an interesting reiteration of the court's willingness to take a commercial, common-sense approach to interpreting the actions of parties where the agreement doesn't address their actions. For companies likely to be undergoing restructuring, it's a useful reminder to specify how and when you want to be able to novate where possible in contracts. For more on developments in contract law, check out our vlogs, blogs and white papers at kempitlaw.com.